Yes, Rick, go ahead. You can hear me okay? Is that what it was for? Yay, good. Well, welcome everybody. My name is Julia Wall. I'm the Director of Education at the Michigan Parkinson's Foundation. This is our virtual education series that we do monthly. Hopefully, you've caught up on some of the meetings we've had in the past, and if not, it is available on our YouTube channel. We do record these. The only ones that are not recorded are any talks that are sponsored by certain pharma companies that will not let us record the meetings. But this one will be recorded. Just a couple of housekeeping notes. We often have many people on here that will ask questions. We want to encourage questions. But with so many people online, it gets a little confusing. You can't even see all the people trying to ask. So using the chat feature is a great tool to ask the questions, or the raise hand feature. Just a couple of announcements to make before we get into our presentation. One, I mentioned that I will be in Lansing at the Lansing Support Group on Tuesday, May 21st at 3 p.m. If you're joining us from Lansing or Lansing area, come on out and stop by for that support group. I also want to remind anyone that you may or may not know that has been newly diagnosed with Parkinson's. And when I say newly, I mean probably about within a year or 2 years. I teach a class every month, the first Wednesday of the month at 10 a.m. At our foundation. If you are in the Metro Detroit area, our headquarters is located in Bingham Farms, and it's called PD 101. It's really a 2-hour class for people to discuss all of their thoughts and feelings and what you need to know, all the things that you wish you would have asked your neurologist when he made that diagnosis and he didn't have time. That's what that meeting is for. If you're outside the Metro Detroit area, we do have a virtual option available as well. We do ask for you to RSVP, and you can always contact me at the foundation. Again, I'm Julia Wall. Next month, our virtual education program will take place on June 19th, and I'm excited about this one. We're going to talk about palliative care, and when is palliative care needed? Are you waiting too long for palliative care? Palliative care is kind of that in-between step between independence and hospice. And that's a long time. And there are a lot of services that are available to many people. And insurance will cover a portion of it as well. I think it's very interesting. So if you want to learn about it, next month, June 19th at 7 o'clock will be our virtual education program. If many of you may see or know Angie Ludwa, who is our Director of Exercise. And Angie is going to tell us about an upcoming event in June as well. So I'm going to switch it over to you, Angie.
Oh, okay, great. I didn't know I was going to be like spotlighted tonight.
I am.
Welcome, everyone. My name is Angie, like Julia said. So in addition to working at the Michigan Parkinson's Foundation, I'm also an ambassador for the Davis Phinney Foundation, which is how I met Jim. So I'm so excited he's here to speak to us. Jim is also an ambassador. So June 26th, it's a Wednesday morning from 9 to 1. The Davis Phinney Foundation is in partnership with Michigan Parkinson's Foundation is hosting a free event in Flint. There's going to be a panel discussing like exercise and care partner support. So that's June 26th. It's from like 8:30 in the morning to 1 o'clock. So just morning, early afternoon. It's a free. If anyone's interested in attending, if you live in the Flint area, feel free to reach out to me at Angie Ludwa. I'm going to put my email in the chat so you can email me. All right, great.
Thank you, Angie. Yeah, I sure hope that we get a lot of people. This is a very exciting event that we're going to put on. Okay, well, with that, I'm so honored and excited for our speaker. Jim Allen is a lawyer joining us to give us all the wisdom that we need. He is a Davis Finney Foundation ambassador as well. He's going to talk about wisdom, law, and practicality in the world of Parkinson's. So I will turn that over to you, Jim. Thank you.
Okay, well, thank you very much. Hope everybody can hear and got their computers running. We want to talk today about employment law. It's a big deal for Parkinson's people because the reality is a lot of us get diagnosed when we're still working. And a lot of us get diagnosed and need to continue working. And it's important to understand what the law does in that regard. I've been doing employment law since 1985. I went to work for an employment law attorney employment law firm in 1985. I learned the ADA before it became law. I was making presentations on it before it went into effect. So I've learned all the regulations and all the cases, and I've represented employers, I've represented employees, I've represented the government. I worked for 5 years with the EEOC as a trial attorney. I've done lawsuits involving disability discrimination in 5 or 6 different states. It's a very simple, basic law, but it's very different from all the other employment laws. So one of the things we want to do is talk about, as we say, wisdom, law, and practicality. The law is one thing. Wisdom is a different thing. Practicality is what you care about because your job is important to you. People with Parkinson's need their jobs, and they need to be thinking about what they're doing with respect to their jobs, because too often people make mistakes and they lose the rights that the law gives them. So we want to go through all this. So I'm going to start with a quick history lesson because I want you to understand how we got to where we are. In the early 1900s, believe it or not, the government was not allowed to make any laws about employment at all. The Supreme Court and other courts struck down any statute about minimum wages, any statute about maximum hours, any statute that limited the right of a person to do any work they wanted to do for whatever pay they wanted to make. The theory was that under the right of liberty, life, liberty, and property, that under the right of liberty, you had the right to live your life the way you wanted to live it. And if you wanted to work for a nickel an hour, that was your business. And the government had no right to tell someone they had to pay you $10 an hour. If you wanted to run a business and you wanted to pay somebody a nickel an hour, that's your business. And you can't be forced to pay anyone more than that and let the market figure out who wins. The sad thing, of course, is as employment changed, the employers always won. And so they decided eventually that that was not such a good rule. And in the 1930s, they changed their minds. The Supreme Court in the 1930s said, sorry, we've been wrong forever. There is no right of liberty in employment at all. There's no limit to what the government can do in employment. So the government can make any rule it wants to about employment. The result of this is a very strange set of laws. Anything that an employer does is perfectly legal unless there's a statute that says it's not legal. So if you wanted to discriminate against someone because they went to the University of South Carolina, you are allowed to do that because there's no law that says it's illegal to discriminate against people that go to the University of South Carolina. If you're in Michigan and you don't ever want to hire an Ohio State Buckeye, you don't ever have to hire one because there's no law that makes it illegal to refuse to hire somebody from Ohio. So when I was interviewing for jobs in Seattle years ago, being from the South, I was constantly being asked questions about the Civil War. That's not illegal because it's not illegal to discriminate against Southerners. But if you're interviewing Japanese Americans for a job, you shouldn't ask them about Pearl Harbor. That's a very different kind of a question. So it's all about what the law says. The only protection you have as a person with Parkinson's is the statutes. The common law doesn't protect you. Logic doesn't protect you. Only the statutes protect you. So you need to know what the statutes are. And if you do not use the statutes, then you will not be protected. So that's why it's important that you understand what you're talking about when you get into these things. So what does the law say to you? If you are the person with Parkinson's, here's what the law says. You have Parkinson's. You need a job. You have to take steps to protect yourself. It is your obligation to take the first step. It's not their obligation to guess what's going on with you. It's your obligation to make the decision as to what you're going to do. That means that you can't be forced to tell anyone that you have Parkinson's. Your employer can't come into your office and say, I've noticed you've got a tremor. Do you have Parkinson's? That's illegal. But the employer has the right to run their business. So if they see that you have a tremor, they have the right to notice that you have a tremor and to worry if the tremor is affecting your job. If they notice when you're walking down the hallway that you tend to lean to the left and fall periodically, they have a right to notice that and take that into account. And if you don't tell them there's a good reason for it, they can fire you for it. If they see your hands tremble and they think it's because you've been drinking, they can fire you because they don't know any different. They get to run their business. So there's this stress between your right to keep your privacy and their right to run their business. So what the law says is the laws that matter are these. The first is the Americans with Disabilities Act. The Americans with Disabilities Act, the ADA, was passed in 1990. It governs the largest number of employees around the world, around the country. Anybody with 15 employees or more is covered by the law. It sets the general standard for discrimination against disability. It's therefore very important, even though Michigan has its own law. It has the Persons with Disabilities Civil Rights Act, which is the lovely name, PDCRA, which is not nearly as easy as ADA. The big difference is that the PDCRA applies to everybody who has any employees at all. But it's exactly the same as the ADA. The standards are the same. What you have to do is the same. It's just that the state of Michigan has decided they're going to apply it to everyone. So if you are hiring someone as your employee to mow your grass, you cannot discriminate against them on the basis of disability, even though you're just hiring one person. Under the ADA, you could. So you have both of those laws, but the standards for the laws are the same. They just apply to different numbers of people. So the law says to you, this is your disability. It's nobody else's. It's nobody's business but yours. You don't have to tell anybody anything. You can keep quiet about it as long as you want. That's your right. In fact, you never have to tell your employer that you have Parkinson's. Even if you seek an accommodation, you never have to tell them why, but you do have to give them a medical report that says what you need. But we'll get into that. But you don't have to tell people. The law is written this way because when it was passed, it was in the middle of the HIV scare. People were scared to death of HIV. And if someone showed up who had HIV, employers would fire them because they didn't want anyone with HIV in their office. They didn't want anyone to get sick. So they made the rule that you cannot be forced to tell anyone. If your disability is so bad that it interferes with your work and you don't want to tell them, you don't have to tell them. You can keep quiet about it and just take whatever consequences come. But you do still have to do your job. You can't have a disability, refuse to tell them what it is, and fail to do your job and still be protected. This is the central thing you've got to know. When I worked with the EEOC, I had so many cases where someone would come to our office. They say, I've got this disability. I've been fired from my job because I had to take this time off or because I had this difficulty with what I was doing. And you know, or I wasn't fired, but they'll say something, they got on to me and they told me that I had to do all this stuff and I got mad and I quit. And I want to sue for disability discrimination. Once you quit your job, you can't sue for anything because you quit. Quitting your job is death in terms of your rights. You do not want to ever quit your job because you have a disability. Likewise, if you don't do your job as well as you need to do it, what you're going to end up with is a situation where they are going to see what's happening with you and they can't ask you any questions. So if you get a Parkinson's mask, a lot of us get the mask very early. You're sitting in a meeting and they're talking about things and they're all excited and you're sitting there and you look totally bored because they can't see any emotion in your face. You're not in any way involved in what they're doing. They have the right to believe that you don't care about your job because all they know is that you don't look like you care about your job. This is very important. The way I ended up with a diagnosis of Parkinson's was my boss called me in. I was at that point in time working as a prosecutor. My boss called me in and she said, we've noticed that when we go to meetings and come out of the meetings, you don't seem to remember anything that happened in the meetings. She was right, by the way. I couldn't remember a thing that happened in meetings. I would go into a meeting and I'd walk out, and it was lucky if I could remember there was a meeting at all. I couldn't schedule things, and I had a tremor in my left hand, which interfered with my ability to type. And they really got upset with me because I wasn't doing my job right. They didn't ask me if I had a disability. They told me, this is what we have seen, and we don't like it. We want it fixed. And I told them, I will go and see my doctor, and we're going to find out what this is all about. And that's how I ended up leading to a diagnosis at the first place. Since they can't ask what's wrong, all they can do is judge your work. They can't punish you on the idea that somehow you are sick, but they can punish you because you're failing. My boss could have fired me because I was failing to do what I was told to do in meetings. My boss could have fired me because I wasn't producing work fast enough because of my tremor. My boss could have fired me because I was forgetting to meet deadlines because of the executive function problems. All of that would have been perfectly legal. Once they raised the issue and I told them I was going to my doctor, then I was protected. So you do not want to keep this secret for long. If they're smart, they will fire you before you get a chance to tell them you have a disability. I'm not kidding about that. That's what they're trained to do. They're not allowed to ask. They don't want to ask. And if they do ask, then they get themselves in trouble. So be prepared for that. So here's the problem with Parkinson's. You can't keep it a secret. Parkinson's is diagnosed on the basis of visible symptoms. That's the way it's always been diagnosed. Tremor, bradykinesia, postural instability, and rigidity. Those are the 4 standards. If you have any 2 of those 4, including bradykinesia, you can be diagnosed with Parkinson's. If you do not have bradykinesia, you cannot be diagnosed with Parkinson's. Bradykinesia means slow movement. And if they see you walking around the office slowly, if they see you unable to keep up with your duties, if they see you having struggles with your tremor, they can fire you because they don't know it's Parkinson's. Now, if the people who live with you can see that it's Parkinson's, if your wife or husband can see that it's Parkinson's, if your doctor can see that it's Parkinson's, how do you think the people who work with you 8 hours a day are going to see it? They're not going to be confused about whether there's something wrong. They're just not going to know what's wrong. You have to be the one to tell them because they cannot ask you. Over the years, I had so many clients, employers who would call me and say, I've got an employee who works for me and I think that she's got an alcohol problem. I'd like to ask her about it. And I'd say, nope, can't ask her. Can't ask her if she's got an alcohol problem. If she's not doing her job, fire her. Because if you ask her, then you've broken the law. So you have to be careful and be ready to talk to them. If you don't want to talk to them, then you just don't have protection. You just don't have protection. So be ready to deal with that. So the practical result of this is, if your symptoms are evident and impact your work, your employer is going to see the impact on your work, and the employer is going to be able to take action. They can suspend you. They can fire you. They can do anything they would normally do in the absence of a disability. So you need to talk to them and tell them what's going on. They'll just act like you're not doing your job, and they'll fire you. And once you're fired, you're out of luck, because then you've got to apply as a new employee. And if you think keeping a job with Parkinson's is hard, getting a job with Parkinson's is much harder. Keeping the job is what you want to do. And it matters to keep your job. Jobs are important. They're important for our health. They're important for our finances. They're important for keeping us mentally sharp. When you leave your job, you leave something of great value. So you need to pay attention to what's going on. Keeping your secret can cost you your job. And I've seen this in so many cases where people would have a condition and they were ashamed of it. They thought, well, I've got HIV and it's a shame to have HIV. I'm just not going to tell them I'd rather be unemployed. That's fine. That's your choice. But there's no reason to be ashamed of Parkinson's. You didn't cause Parkinson's. Nothing that you did made it happen to you. You can't stop it. You can't make it go away. So there's no shame to having it. You need to keep your job. So be very careful if you get too caught up into trying to keep my secrets. So here's what happens when you get this. You have to ask for an accommodation. You have to tell them you've got a problem. And you have to identify what the problem is and ask them to fix it. Under the Americans with Disabilities Act, you can ask for this anytime you want. You don't have to tell them the day you get diagnosed. You don't have to tell them the first 3 years that you're diagnosed. They don't care. The minute you tell them you have a disability, the law kicks in. So you can wait all you want. But under Michigan law, you have to tell them within 182 days. I have no idea why they would do that in the Michigan law, because it doesn't make any sense to me. But in that law, it's 182 days, which is basically 6 months. That's how they've come up with the odd number of 182. You'd think 180 would work, but no, they make it 182. In theory, if you're having trouble at your work and you get a Parkinson's diagnosis and you wait 7 months, you no longer have rights under the Michigan Civil Rights Act. You've still got the ADA, but the Michigan law is gone. So you have to make this decision quickly in Michigan, as opposed to in most places where you can just wait until you want to make a change. So you get to tell them about the accommodation. If you don't want any accommodation, if you don't want them to take into account, then don't ask for anything. Just take your chances, continue to do your job. But if you go to ask, be prepared when you go in. Go in with a list of all the things that you have trouble with in your job. Maybe you're having trouble answering the phone. Maybe you're having trouble typing. Maybe you're having trouble carrying heavy things. Whatever the difficulty is, you need to tell them what you're having trouble with, because that's the accommodation requirement. They have to accommodate the difficulties you have with your job. So you go in prepared. Don't go in and say, I've got Parkinson's, I need an accommodation, because that doesn't tell them anything. Nobody knows what Parkinson's means for you. They can't tell you. They don't know how bad your tremors are. They don't know how bad your bradykinesia is. They don't know how bad your executive function is. They don't know if it's affecting your memory. They don't know if it's affecting your ability to eat. They don't know if it's affecting your ability to hear, because it's so individual. So you need to go in with a list and tell them, this is what I'm having trouble with. Don't tell them I can't do these things. Tell them, this is what I'm having trouble with, because that's the question for them. Can they accommodate what you're doing? You go to your supervisor in most jobs. If you're in a large employer, you go to human resources. Supervisors in large employers are not prepared to deal with requests for accommodation. HR deals with them. When you deal with HR, you're dealing with people who are trained, if they know what they're doing at all, in how to deal with accommodation. They will deal with your supervisor. If you've got a good relationship with your supervisor, speak to your supervisor, but don't be surprised if you get sent to HR. By the way, when you get sent to HR and you talk to them about accommodation, they will not talk to your manager about what's going on. They will not tell your supervisor. They're not allowed to. They're not allowed to tell anybody what you tell them. They can't tell your coworkers. So if you have a job where you do 6 different things and you can still do 5, but not the 6th one, they can assign other people to do the 6th one, but they can't tell them the reason they're doing that is because you have Parkinson's. This makes for a lot of fun in the workplace, but that's the law. And you don't have to help them out in this regard. They're not allowed to tell. Your union is not allowed to tell if you're in a union workplace. So you go to human resources, you tell them what your list is, and then they should prepare for the accommodation. Take the list of problems, take the things that make it hard for you to do these jobs, and then go talk to them about it. The law requires them, not you, them, to make a reasonable accommodation. It's their duty. It's not your duty to figure out how to do it. So if you're having trouble typing because of your tremors, there are lots of ways to cope with being unable to type. You don't have to tell them how to do it. They have to figure out how to do it. There's an entire network of facilities that tell them how to do these things. There's an organization called the Job Accommodation Network, which exists for the sole purpose of telling employers how to accommodate disabilities. A reasonable accommodation is any change in the work environment. Understand what that says. Any change. There's no limit to what a reasonable accommodation can be. Any change in the work environment or in the way things are usually done to help a person with a disability apply for a job, perform duties of a job, or enjoy the benefits and privileges of employment. So, for example, let's say that one of your difficulties with Parkinson's is that you can't go up and down stairs. You have to have an elevator to get anywhere. You cannot get up and down stairs. They cannot have their Christmas party in a non-accessible place that you would have to go upstairs to get into, because then you couldn't go to the Christmas party, and that would be discrimination. They have to accommodate you in any respect that they can that's reasonable, no matter what the change would be. So it's a very broad right. It's a very big picture for them. And the amount that costs them is not particularly important. If you have a job making $25,000 a year, and it's going to cost them $25,000 a year to add to your cost to accommodate you to buy special equipment, they still have to buy that equipment unless they can prove to the government that they can't afford it. So it can become very pricey, but the reasonable accommodation is what you're always looking for in these situations. So identify for them what your medical issues are. You don't have to tell them what you have. Tell them this is my problem and what you need help with. From my point of view, I just tell them I have Parkinson's. That's what I went to my diagnosis, and I went to my workplace and I said, this is what I've got. This is why I'm not doing good in my meetings, because this is my situation. Because I don't see any reason to keep it secret. But if you see a reason to keep it secret, then you don't have to tell them what it is. By the way, if you're trying to keep it a secret, you have to keep it a secret from every single person in that office. If you tell your best friend, they're going to find out. If you tell anybody, it's going to get around. No one's going to hear she's got Parkinson's or he's got Parkinson's and keep their mouth shut. That's not the way it works in a workplace. So you need to tell them if you're going to tell anybody. You can offer suggestions. You can tell them, I can't type anymore, but I still have to send emails in my work. I need to do that by talking into a microphone, and I don't have a microphone. I need you to buy me this $15,000 microphone set. And they're going to say no. They're not going to buy you a $15,000 microphone set, but they're going to buy you something that will allow you to do the job. You can suggest what you want. My recommendation is not to suggest anything. It's their job. If they ask you for a suggestion, then give them one. But don't go in with a list of what your demands are, because you'll scare them away, because almost everybody picks things that are more expensive than what the employer is going to have to buy. So just tell them this is what I need. You can offer suggestions, but the burden is always on them. So, are you a person with a disability? That's the first question you got to find out. Parkinson's is a disability. A disability is a substantial impairment that significantly limits or restricts a major life activity or affects a major body function. Parkinson's does this. Parkinson's affects your brain. That's a major bodily function. That's a major part of your life. It affects the way that you think. It affects the way that you move. It affects the way that you digest. It affects almost everything in our lives. We all know this. So it is, in fact, a disability. If it's at the stage of diagnosis, then it's visible, it's obvious, it's a disability. If you have advanced Parkinson's, obviously that's a disability, because there are significant problems with advanced Parkinson's. And the cases will say that advanced Parkinson's is clearly a disability. Everyone else, you have to show that it's a disability, but it's never really been a challenge. Almost no one ever gets denied accommodation because they don't have a disability. So the accommodation can be anything. Anything that makes you able to do your job. So special equipment, special furniture. If you need a walker at work and you need them to provide a walker at work, they don't have to provide that, because that's not work material. That's a personal item that you bring to work. That's like eyeglasses. But if you work in a place where you can't get a walker into work, then they would have to give you one at work, because it would be specifically aligned with work. If you need special furniture, if you need a stand-up desk, because for Parkinson's, you have to stand up sometimes. You can't sit all the time. They have to get you a stand-up desk. They have to accommodate whatever's going on with you. They might have to give you extra breaks. I know if I were at a full-time job now, I would have a problem, because I can't work 8 or 9 hours in a row. I can do 2 or 3 hours, but then I've got to have a break. And they may need to give you extra breaks, and the law can require that. Now, they don't have to pay you for breaks that are extra breaks, but the law can require them to give them to you. They might have to give you memory aids. I used to go to meetings. I couldn't remember anything in the meetings. If I walk out of the meetings and I don't remember what happened in the meeting because of my disability, that's a reasonable accommodation issue. I could take notes in the meeting, except I have micrographia, so I couldn't read my notes anyway. So they would have to have someone take notes in the meeting and give them to me so that I could know what happened in the meeting. That's a reasonable accommodation. No one else has to come to the meeting, but someone at the meeting has to take notes, because that's a fair way to accommodate that particular problem. What if your difficulty is with speech? A lot of people with Parkinson's have difficulty with speech. They have difficulty forming words. They have difficulty expressing their ideas. An employer can be required to give you more time to answer questions. So when you're all sitting around in a meeting and everyone's fireballing questions, they can be required to tell everyone, okay, shut up, Jim needs to talk, and let you talk. And if you hold up your hand and you say you want to talk and they call on you and it takes you 10 minutes to get your answer out, that's their problem. They have to accommodate because you need time to express the ideas because of your condition. It impacts each person differently. So what's going to be needed for you is going to be different than what's needed for anyone else. You cannot do a search on how to accommodate Parkinson's and get a list of things you want to do. When the law first came out, this drove us crazy. I was working for an employer firm at the time. We represented companies. All the other discrimination laws just said, be nice, don't be mean, don't fire people, don't refuse to hire people. The ADA says, do nice things, pay money to do things that you don't have to do to help people with disabilities, no matter what the disability is. So, for example, I had a client who had an employee who applied for a data processing job. She was a quadriplegic, and she wanted a data entry job. She couldn't type. How does she do data entry? She does data entry with a light that's on the side of her head, which shines onto a computer screen to spell out the things that she wants to input into data. And she could do that as quickly as was required by their standard for typing. And therefore, they hired her and spent $20,000 on equipment so that she could do her job, because that's reasonable accommodation. If your Parkinson's requires accommodation that no one else's does, that's okay. They still have to do it. They can't say, well, my mother had Parkinson's and she didn't have this problem, because it doesn't matter what any other person's problems are. All that matters is what you're dealing with. So don't hesitate on this. Don't put these things off. The sooner you let them know, the better off you are, because you're going to need less accommodation. As time passes, you're going to need more. Get them used to accommodating little things. Get them used to giving you a little more time when later you're going to need a lot of time. Get them used to letting you have a few breaks when later on you're going to need more breaks. You want to start this early so they will understand what they have to do. The second aspect of this is, what are the duties of your job? They only have to accommodate for the duties of your job. So let's say you're the receptionist at a large company. You sit at a desk, people come into the room, I introduce themselves to you, tell you who they're looking for, you get on the phone, you call that person's secretary, they come and get them and take them to the meeting. Maybe you have to get up and distribute the mail, you have to answer phone calls in general. Those are all jobs that a receptionist commonly does. If you can't do one of those jobs, then can you be a receptionist at all? The answer of the ADA is, it just depends on what a receptionist is in that workplace. Does the receptionist give the mail to everyone? Well, that's not really a receptionist job. That's somebody else's job in most large places, because they'll have a mail room that'll take care of taking mail to people. So that duty can be given to someone else, and you can continue to be a receptionist. I'll give you an example. One of my favorite examples to tell people about how accommodation works was this. I had someone ask me in a seminar once, if a person who is really, really hideously unattractive because of a physical condition, and this is what they said, if the elephant man applies to be a receptionist, do I have to hire him? And the answer under the ADA is, if he can do the job of a receptionist, yes, you have to hire him. The fact that people might be put off by his appearance is not an excuse to refuse to hire him. If he can answer the phone and tell people where to go and greet people in a pleasant tone of voice, then he can be a receptionist. The fact that you don't want him there because he doesn't look the way you want a receptionist to look is not enough reason to deny him the job. This is exactly what happened in the 1960s when a lot of stores would refuse to hire a black waiter, or excuse me, a black salesperson in a clothing store because they said people wouldn't want to be waited on by a black person. And the answer of the law was, we don't care. We don't care what people want to be waited on. We're trying to change the world. And if you refuse to hire someone for that reason, you could be sued and lose. So accommodation is very broad. It can reach a lot of things. Whatever the essential functions of your job are, those are the things you have to be able to do. Little things they add to your job are not essential functions. The essential functions are the things you have to do. I was a prosecutor in the job that I had. I had to handle trials. I had to handle plea bargains. I had to negotiate pleas. I had to review files. I also had to carry files to the courtroom. But carrying files to the courtroom is not an essential duty of being a lawyer. Anybody can carry files to a courtroom. So they would have to get someone else to carry the files to the courtroom because I couldn't carry the files to the courtroom, but I could still go to the courtroom. What are the essential functions? And the essential functions are discovered by figuring out how your job actually works. Your employer, if he's a good employer, will have a list, a job description. If you ever looked at a job description, they'll describe what the job is, and then they'll say essential functions. Whatever that list says are essential functions, those are the functions that really matter. So the employer's judgment matters, what the actual work experience is. If my job description says one of my jobs is going downtown every day and getting coffee for my boss, but I don't actually do that, then that's not an essential function, no matter what it says on that piece of paper. How much time you spend performing a job is an important part of essential functions. What happens if you don't perform the job? All these things come into it. The terms of collective bargaining agreements are very important. If you have a collective bargaining agreement that says that if you're in job A, you can't do any of the duties of job B, that collective bargaining agreement will govern the discussion of accommodation between jobs A and B. So this is complicated. That's why you just go to your boss and say it's your problem. You don't have to figure it all out. They have to figure it out. Once you put it on their table, it's their responsibility. So here's how it works. It's called an interactive process. You go to the employer and you say, I've got a condition. This is my medical issue. These are the things I'm having trouble with. That's all you have to do. Now, they can ask you for a record from your doctor that backs up what you're claiming to be a problem. You have to get that for them. If they want to, they can send you to their doctor and have their doctor confirm it, but they do not have to know what your condition is. They just have to have a doctor fill out a form. It's a standard form. It's used all over the country. It's very easy to do. Do not refuse to do that. I've had people come and say, they wanted me to fill out a form. I refused and quit. Well, then you've lost your job. All right, you wanted me to fill out a form. I refused and they fired me. They have a legal right to fire you. You refuse to fill out the form. Take it to your doctor and get the form filled out so the doctor can tell them what the story is. Complaining, by the way, is not enough. You have to tell them it's a medical issue. You can't say, I'm having trouble doing this. Could you fix that for me? You have to say, I'm having trouble doing this because of a medical condition. Then they have to do it. So be very careful how you go at this thing. The employer then responds by talking to you. They should sit you down and say, describe for me what your difficulties are, what your problems are, what you think needs to be taken care of in your job. The employer then examines the problem. They will assign someone whose job it is to talk to you and talk to your boss and talk to people and figure out what needs to be done. They have to research what their options are. And then they have to tell you what you can do. You can help them by giving them advice. You can give them information from Davis Finney. You can give them information with the Parkinson's Foundation. You can send them to the Job Accommodation Network. The Job Accommodation Network is excellent. They have a website. You can get all the information you want from them, but you can help them, but don't make it your responsibility. It's their responsibility. Now, they're going to come to you and propose an accommodation. That's their job. They're either going to say we can or cannot accommodate you. If they say they can't, well, then you're going to end up finding yourself in a lawsuit because they're refusing to accommodate. Make them explain what it is they're refusing to do and why they're refusing to do it. If they propose an accommodation and it's not the one you want, do it. Do it anyway, because it's their call. So if you need a particular piece of equipment and they say, no, we don't think you need that equipment. We think you need this equipment over here that's a lot cheaper, and they buy you that piece of equipment, use that piece of equipment until you can prove that it doesn't do the job. You have to try the accommodation they offer and then tell them it didn't work, because their duty to accommodate continues as long as you work there. So when your condition gets worse and you need more accommodation, they can't say, well, we already accommodated you, we don't have to do that anymore. No, they have to do it forever. It's an eternal duty. When your condition changes, their accommodation duty changes. They can't just stop. The employee should try anything they offer. Don't just get mad. Don't say, no, that's not going to work. I was dealing with someone the other day whose problem was they'd asked for an accommodation and the employer said, okay, but we're going to have to put you on this doctor. It was a nurse. We're going to have you work with this doctor because of your new schedule. Well, I don't want to work with that doctor. Well, they've got to offer an accommodation they want to offer. They don't have to let your doctor work your hours. They can put you with a different doctor. Try anything they offer because you want to keep your job. If it doesn't work, go back and tell them it didn't work. That's how it works. That's how you do it. Be very patient. This can take a lot of time. It's not easy to get this resolved. You can't go to your employer today and tomorrow it's going to be solved. Sometimes you'll go to your employer and say, I've got this problem, and they'll say, it's going to take us a little time to figure this out. Are you okay until then? What can we do until then? Sometimes they'll send you home on a suspension with pay. If they send you home on a suspension without pay, that's a problem, because they have to accommodate you. You don't have to accommodate them. But it can take time to find an accommodation. The harder your challenges are, the harder the accommodation is going to be. If you're currently, for example, in a management job and your problem is executive function and you can no longer handle the management job, that presents a real difficulty, because they have to decide how they can use your skills in a different job. And that sometimes can require you to take a lower job. But it can take time. So be very patient about this. Be cooperative. Show them that you value the job. Show them that you respect them as employers. Don't go in there with your back up and yelling and screaming about what your rights are. Your rights are simply to get an accommodation. Be as nice as you can be. You're cooperative with them. You just want this to work out. You just want this job because you like this place. You like working here. Everything's great. You don't walk in and say, well, I've got a right to accommodation. This is what I want, because you immediately put them behind the 8 ball and you're never going to get out. So you want to be very careful about that. And remember this, a job is always better than a lawsuit. Always better than a lawsuit. People will say, if you don't do this for me, I'll sue you. And the company's answer, if they've got any sense, is go for it. Lawsuits take 2 to 3 years to resolve. The lawyer's going to take 40% of everything that you get. You're going to have to be deposed. And in those years, you're going to be unemployed. And if you think being unemployed for 2 years and ending up with 50% of what you thought you were going to win is a good deal, well, that's fine. But a job is a better deal. If they fire you and you get another job that pays as much money, you can't sue them because you didn't lose any money. I actually had a case involving a person who was fired because his wife had cancer. He was hired in a job to be a private pilot for a company to come to fly the corporate jet. And they found out that his wife had cancer, so they fired him. They took away the job offer because the people in the company said, we don't want to fly in a plane with a guy whose wife's got cancer. What if he panics? Well, that's illegal. So we sued them. This was on behalf of the government. And it was a great lawsuit. We were going to win the lawsuit. The trouble is our guy got a raise 3 months later at his other job and he ended up making more money. So we weren't going to get much money out of it anyway. So we got him $40,000 and he went away and he was happy because there's nothing else you can do. But don't just quit and sit around waiting for a lawsuit. Lawsuits take forever. They're never going to get you the kind of money you get with a job, and they're not going to get you the kind of pride that you get with a job. These laws are very important, and you need to be protecting yourself in regard to these things. So let me let you get some questions here. I'll see what we got in the chat or how we want to handle questions.
Yeah, this is just so helpful. Wow, I learned a lot. No, I do. And I have a couple questions myself, but the first question came from Anne Marie in Michigan. Do you have to tell your supervisor or HR within the 182 days?
That's what the state regulations say.
Okay. Yeah, I thought that part was worth repeating. Well, but if anybody has any questions, feel free to raise your hand or jump on the chat. But I wrote that down actually that first of all, there's a difference between the ADA, the American Disabilities Act, and then the Michigan, which was that went by too fast, PRCA or whatever it was. And
People
then
with Disabilities Civil Rights Act.
okay, great. And that 6 months, you have 6 months basically from when you decide to
Learn
come
of your
out,
disability. When you learn of the need for an accommodation.
when you learn to, okay, so not necessarily 6 months from your diagnosis, not 6 months from when you decide that you want everyone to know, but 6 months from when you realize that you're going to need accommodations to complete your job.
I think that would be the most liberal way to see it. The main thing for that is if you're in a place with less than 15 employees, you're going to have to do that because otherwise you're not going to be covered by the law because the ADA doesn't cover you. And what it does is it's, I think, intended to protect the employers. I think it's a terrible rule.
Well, it sounds like a terrible rule because with Parkinson's, as we all know, it's so unpredictable from day to day, let alone 6 months down the road. How do you know what your accommodations are going to be a year from then?
And you never know what a judge is going to do. When you give a judge a rule like that, the judge may look at it and go, well, that's a rule, you lose. Or the judge may look at it and go, well, I don't like that rule, so you don't lose. It just creates a problem. And you don't need that kind of problem. So as soon as you're aware that you've got to, now, if you get diagnosed with Parkinson's in your early stages and there's nothing really going on, it would seem to me it would be very odd to say you have to report that because the whole point of these laws is to say you don't have to report until it's a problem. But that's what their rule says. So
yeah, no, I think that's great for clarity. I did not know that. I really appreciate that. If anybody has questions, hop in, or I'm just gonna keep going because my mind's a spinning. This was great, honestly. I'm so glad. I learned so much. I thought maybe, do you have a better way to explain? You know, a lot of times people will say, I got diagnosed with Parkinson's. I've been working for the last couple of years, but it's getting tough. We all know how anxiety can interfere with life. I think I'm going to get disability. I'm just going to go on disability. So there's a lot of confusion with that, I think, between Medicare disability, work environment disability. Could you talk about that for a minute?
sure. The three things you're primarily concerned about, one is short-term disability policies. Many employers have a short-term disability policy. A short-term disability policy means that because of your medical condition, you cannot perform the job that you used to perform. But that's a much harder standard than reasonable accommodation because they're saying you can't do the job. Not you can do the job barely, you can't do it. So to prove that you're disabled, you have to show that you cannot do that job. Short-term disability is normally something that's not hard to get. It'll normally last 6 months. At the end of 6 months, you will go on what's called long-term disability, which again requires you to show that you can no longer do that particular job. And the long-term disability will require you to certify that every year. Again, just yesterday, I got a complaint from someone. They were saying, yeah, but I'm on long-term disability, but every year they make me fill out these forms. And the answer is yes, because you're on long-term disability. So every year they're going to make you fill out the forms because they want to make sure you're still disabled. They don't want to pay you for the rest of your life if you don't remain disabled. I know it's disability because it's Parkinson's. It's going to stay forever, but they're just doing their job. So you want to be careful with that. Then you get SSDI, the Social Security disability. Social Security disability is much harder to get. You have to be able to show that you can't do any job that would get you $1,700 a month. If you can do any job that would make $1,700 a month, then you cannot get Social Security disability. So that's a much harder standard. And because it's the federal government, it takes a lot longer to get that standard met because you got to go through the judges, you got to go through their processes. It can take months or even a year to get that. Once you get it, they'll give you back pay, which is a kind of a tricky thing because your back pay is actually taxed as a gross income. So when you get a big back pay number, you better put half of it in the bank because you're going to end up giving it to the government. But Social Security disability means you can't do any job. Short-term and long-term means you can't do that job.
I do have to give a shameless plug really quick here, Jim. We're very fortunate, the Michigan Parkinson's Foundation. We have 2 lawyers on our board who offer pro bono services for people with Parkinson's. And when it comes to Social Security disability, we have one who has 100% success rate. So that's my shameless plug. If anybody has questions about it, you can contact us at the foundation and we will put you in touch with those lawyers. If it's something a little more complicated, they may refer you out, but it's a wonderful service. I just had to give that plug. Okay, back to the questions. Thank you for that. Carl was asking, what does executive function mean?
Executive function refers to your ability to plan, to organize, to remember, to multitask. That's usually what executive function means. Executive function refers to that aspect of your brain that controls planning, organizing, multitasking, and carrying out tasks. One of the early symptoms of Parkinson's is mild impairment of executive function. And I have found that in almost everyone that I've talked to who was in a profession and was diagnosed with Parkinson's. For example, I had to give up my job because I couldn't do trials anymore. I could not handle the witnesses, the jury members, the questioning, the entire process of conducting trials. I simply could not handle anymore. So that's what executive function means.
Great. Srini, I know you had a question, right?
Hey, Julia. Yeah. My question is, do we have to talk to the HR or can we talk to the supervisor and that's okay also?
You're talking about, can you talk to the supervisor or the HR?
Yeah.
Yes. If you talk to the supervisor, you have talked to the employer. The burden is then on the supervisor to do the job and let HR know what's going on. Now, you may talk to a supervisor and they'll say, well, you need to contact HR. Well, then you contact HR. But whoever you speak to who's a boss, they have to respond. Now, if you talk to a foreman, like if you're in a factory and it's a foreman, that doesn't count because a foreman is not a manager. But if you speak to a supervisor who's in a manager job, that's sufficient.
And in my case, my supervisor is very, very nice. My supervisor is very nice guy. And also their supervisors are very, very nice people. So everybody knows in the chain. But I never went to the HR and I never told them saying they have Parkinson. But in my management, everybody knows.
Yeah, I'm not sure I understood what you're saying. You're talking about going up the chain?
In my management, if everyone knows about it, but I never went to the formal HR and said they have Parkinson's.
Yeah. And the trouble is, the more people you tell, of course, the more people that know what's going on. I would go to HR if I was in a big employer anytime.
I work for Ford Motor Company.
What's that now?
Ford Motor Company.
Ford Motor Company.
Oh yes, I would go to HR at Ford Motor Company.
Yeah, if you can find it.
And do not try to go through your union. Go to Ford Motor Company.
Yeah, I'm in non-union. I'm in non-union.
Okay. Yeah.
Non-union. Okay.
Unions, by the way, are terrible on this. Unions not necessarily care about disabled people. Unions want people that pay union dues. And I have not found unions to be helpful in any position I've been in for disabled people.
Wow.
So my question is it do I need to hire an attorney to go to my HR, or can I just go and tell my HR?
Well, I think
Yeah.
he was saying that once you decide to go, you only have 6 months in Michigan. Right? Once you decide to tell them you only have 6 months in Michigan for them to make accommodations for you.
You have 6 months to tell them, and then they have whatever time it takes to make accommodation. There's no limit on their time.
I feel at this time, since I had my DBS done, I don't need any accounting from them. I am doing my job, but when I'm talking, it's not very clear. You can see that, right? When you're talking, my voice is not that clear.
Yeah. Yeah. I'm actually surprised you're still working. Wow, that's awesome.
Yeah.
I'm so happy to hear that. Yeah, I mean, I could see how someone, that they notice that your voice might be softer or it might be a little difficult to understand or something like that. But if I'm right, Jim, they can't ask you about it.
Correct. They cannot ask you.
They can't ask you, but if you're not doing your job, they could bring it up, right? Like this is impeding your work or something.
So if you were a boss and they can't hear your voice, well, then you can't direct your workers and you can't do your job. So you need to tell them this is a problem, and they have to get you an amplification unit so that they can hear your voice when they talk to you, because that would be the reasonable accommodation.
Yeah, it's a little trickier than I thought, to be honest with you.
It is.
I know we had another question. Well, there was a statement, ADA doesn't cover business less than 15 employees.
Correct.
And
now,
then
it counts employees very broadly, by the way. So if there's a person that works there and runs it, but is not an employee for other purposes, he is an employee for purposes of ADA. So it's a broad count, but it's still 15.
Okay. And then Keith, you have a question if you want to unmute yourself. Keith from Grand Rapids.
Yes, hello. Thank you very much for putting this on. My question, which has been kind of a general question in my mind, but then this whole conversation is making it a little more specific to me. I saw the neurologist first in November of 23, and they felt that I needed to be tested. They assumed I had Parkinson's, and she wanted to start me on medication right away, and I started on Carblivo following that November appointment. I waited to have my MRI, and then that took place in January. Then I saw the doctor, and basically I think it was at that point you could say that I was confirmed of having it, but then we scheduled the DAT scan in February. So, I mean, what is my considered found out I have it date? Is it the January date? Is it the confirmation date of February after the DAT scan? Is it when she first suggested it in November?
To me, it would be a diagnosis day. It would be a day where you know the answer, not a day where the doctor is still trying to figure out the answer.
And it won't be the day of the DAT scan, because DAT scans do not confirm the diagnosis of Parkinson's, but it is definitely leaning towards that diagnosis. So I'm guessing the follow-up, I would say they're because a lot of times the neurologist will say, I suspect you have Parkinson's disease. I'm going to start you on this medication. If it works, there's a good chance you have Parkinson's disease. So oftentimes that is the diagnosis. But, you could even speak to your doctor and ask for that confirmation diagnosis date in your chart. By
the way, I looked it up while we're sitting here, and it absolutely is. Failure to notify an employer within 182 days releases the employer from its duty to accommodate under the Michigan law.
Wow. I think we got to start writing our congressman. What's up with that?
Your state legislature.
Yeah, what's up with that? Okay.
And that notification, should that be verbal, written? How
In any way you
Okay.
want to do it, but if you any way you do it, make sure you make a memo of the fact that you did it. If you give them a note, that's certainly a good way to do it if you keep a copy of it.
Okay, because yeah, I talked with HR in January following my appointment, but I
Good.
never asked for any accommodation. I just told them I had been going through this, I've been tested, and this is what I have.
Well, you're
Sure.
running out of time.
Well, we can continue if you want to, or we can leave if you want to. It's up to you.
No, I meant you're running out of time, Keith. Like,
Oh, run out of time on that. Yeah, I thought you
yeah.
about the meeting.
Because you know, because you told him in January, but you didn't ask for accommodations. So does that
Yeah.
mean then he's got to do something before July 1st, right? Or June?
No, I don't think so. I think the fact that you've told them about it puts them on notice that it's there. But I would argue, if I were representing you, I would argue that once you put them on notice, they're on notice. If things change because your condition changes, then you're just telling them you're continuing with the condition.
Oh,
I mean, they can't say, well, you didn't tell us in January that you were going to need this in December. That's not going to work. I can't believe even Michigan would let that get through. You just have to tell them that the problem exists.
Right, which I did.
Yeah.
okay. Well,
All
I
right,
know
thank you very much.
we are running out of time, so I think we could probably answer maybe just the last two questions. And then if anybody
Okay.
else has any other questions, I'm happy that people can email me, and I'm happy to reach out to Jim or our lawyers in the office as well. But let's go ahead and finish up with these last two questions. I am a stenographer, self-employed. What if an attorney I work for has a complaint against my work product? Do I have to disclose?
If you believe that your condition is what's causing the difficulty with your work product, you ought to disclose. That's the only way to answer that. If the work product is not good, but it has nothing to do with your condition, there's no reason to tell them because it's not an accommodation issue.
Okay.
I know Erica had a question. I don't know.
Oh, Erica was Keith.
Oh, okay, never mind. Gotcha.
I told my supervisor of my diagnosis within the 180 days. However, I do not yet need accommodations. Will I be entitled to accommodations later if I need it? Yeah, that seems like that's the very murky area.
That's the same thing we were talking about. Under the ADA, of course you would, because the ADA doesn't care what time you do anything. Under the Michigan law, I really don't know the answer. The answer is you have to tell them when you become aware of the need. Because it's a condition that continues, I can't believe the state's going to say that the fact that it got worse, you're going to lose it. But the statute doesn't say that. But I would find it very difficult to imagine that the state would allow people to get away with that. That say that whatever condition you had within those 6 months is what's going to control, because you might have Parkinson's for 30 years.
Right.
And, you know, Michael J. Fox when he was 35 is not Michael J. Fox when he was 55. But it's the same condition.
Mm-hmm. Yeah. And the ADA wasn't, I think, I don't know when the ADA became, I don't know what year that was.
1990.
1990, yeah. Because I will say, my dad, he had Parkinson's. He was diagnosed when he was 36, and he was fired from his job in the 1970s because they couldn't read his writing.
Yep, that was one of the things my boss complained about too. We can't read your writing.
How would an early medical retirement work at a large corporation?
That would depend entirely upon what the deal is at that corporation. Each corporation is going to have its own arrangement. Medical retirements are very variable. They change. Different companies have totally different standards. So you'd have to check with those folks.
And then again, I just want to let people know, like, if you're in Michigan, and we have two lawyers on our board that are absolutely happy to help and answer these questions. And if you're thinking about going and filing disability or other areas, you know, it's maybe worth getting the free conversation for some direction.
If I can say one thing we didn't get to talk about is the question of applying for a job. When you apply for a job, you do not have to tell them you have Parkinson's. You do not have to tell them you need an accommodation. What ought to be on the application form is the following question. Will you be able to do the essential functions of this job with or without reasonable accommodation? Language like that should be on every application relocation done anywhere in the country? Because that's the standard. The answer to that question is yes. It's always yes. They're not asking if you need accommodation. They're asking if you can do the job with or without an accommodation. That's the subordinate clause. Don't worry about it. Just answer yes. You don't have to tell them there's any problem. When you show up for work and they tell you what the job is, if you know immediately that there's an issue, that's when you tell them. And you say, oh, well, I have this situation. I'm going to need an accommodation for that. And at that point, you're an employee and you're protected by the law, and they have to deal with it.
This is great, Jim. You're so knowledgeable. Where are you located at?
I'm in Augusta, Georgia now. I've practiced law most of my career in Seattle. And then I practiced all over the country, but I was based in Seattle. And then I came home and worked here in Augusta for a few years. And I worked for the EEOC down in Savannah. Did lawsuits in the Carolinas and Florida, Georgia, and Texas.
And still working?
I still do some legal work for a friend, but I can't do litigation anymore. So
Yeah. Well, gosh, your knowledge has been so greatly appreciated. I loved it. So I want to thank you. I want to thank everybody for attending. I want to be very respectful of time. So again, this will be recorded. In fact, I'm going to make sure my husband watches this because he needs to watch this. Not for Parkinson's, but so I can't thank you enough. And with that, I will tell everyone good night. Thank you for joining us. Jim, thank you. Thank you.
Jim.
Thank you.
So
I look
good to
forward
see
to
you.
seeing you again.